My never say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
Sammy knows that not necessarily would the Chief Justice right to inform the plaintiff. He's the lawyer, but it's not procedural to say that because you are seeking the Chief Justice to expedite or the court to expedite your case because of some urgency to it. It is not incumbent on you to want to inform the plaintiff. It is from the court, having received your application or your letter for expedited hearing. They now serve a notice of hearing to the plaintiff in the matter to say that this case will be heard this day or that day, which is what is in contention now.
No, explain this so that I understand. Let me ask the question so that the clarity can come. Are you saying, this is what I heard, but I could be wrong. Are you saying that when a party in a suit files for abridgment of time per the practice or the rules of court, that party in the suit needs not inform or copy the other parties in the suit?
Yeah.
And that when the said application goes to a registrar and therefore the court, if it agrees and grants that, will only have to inform the other parties in the case of the hearing, the date for hearing.
Yeah.
Is that your case? That's what you said?
That's my understanding.
Okay.
To the extent that the burden is not on the person, so it could be the plaintiff or the respondent in the case who is seeking for abridgment of time. So the burden is not on the one applying for such expedited.
Who will it be on?
It will be the court then will notify me, assuming it's between you and I. Okay, then you apply.
So this is the clarity I wanted.
Exactly.
So what you're saying is that per the practice, it is not for the AG. We are being specific.
Exactly. So
it's not for the AG to have informed the parties that I have applied for abridgment of time. However, it is the responsibility of the court to inform the other parties that this party in the matter has filed for abridgment of time, and therefore we will hear that motion on this day. Is that what you're saying?
Exactly. So that the burden. Hold on. No, it's okay.
Sammy, just
I mean, we have 1,001 lawyers listening, right? The point I'm making is that the burden of communication is on the court.
Okay.
To say that this case will be heard on so and so date, subject to the application for abridgment of time in this matter. So it is not for the person seeking the expedition to be the one to inform you. By the way,
but from what you're saying, that all parties in the case will be made aware that there is an application for abridgment of time. However, what you say is that it is not the responsibility of the in this case the AG, but the court will have informed them that there's an application.
There's a notice. They will serve a notice of hearing saying that this case will be heard on that day.
Because a party in the suit has applied for abridgment of time.
I'm not sure if you say that exactly, but the burden is on the court to inform the individual of the notice of hearing that this case will be heard on this day. Whether the details will include that because of abridgment of time, that we can hear other people's view. But the point is that the one applying has no responsibility to inform you necessarily before it is effective. So nothing wrong in the process that the AG has undertaken to say that the AG Nicodemously had an application. It was a concert between him and the CJ, which Sammy was saying. I don't think that is exactly the case.
Doc, Richard is lost in the jungle. He doesn't have a clue about the issues we are discussing. I don't know whether he spoke with the AG before he came. Because if he did, I'm sure he would have educated him. Because the kind of things Richard is saying on this matter, I'm shocked, Doc, we are confusing two things here. And it's important that we clarify so that those watching who are not lawyers can be educated. What Godfrey Dame, the Attorney General, claims to have done is not a motion for abridgment of time. When we say motion or an application for an abridgment of time, or of abridgment of time, what we mean is that, you see, Doc, usually when you file your case in courts, the registry of the courts, when they write the suit number and everything, you know, they stamp it and everything, they give you a return date on the face of the process you have filed. The return date is the date that the court will be hearing the matter. But there are times that the courts may be, you know, overstretched, or for one reason or the other, the registry of the court may not be in a position to give you a hearing date upon filing the process. So if the registry is able to give you a hearing date upon filing, and say this, they give you a hearing date of 1st April, you understand, as the return date for the hearing of your application, then before that 1st April, the court on its own motion, or a party to the case by an oral application, can apply to the courts for the date to be abridged, meaning for the date to be brought forward from 1st April to 28th March, or for the date to be extended. So you only motions on notice, okay, or notice of motion for abridgment of time are filed when a hearing date has been fixed, when a matter has been fixed for hearing, and a party thinks that the date is too far, then the party goes to court and applies on notice to the other parties that, my lord, can we bring the date forward? In some cases, they apply for extension and it is extended. But that is when you have been given a hearing date. Now, in the case of Roxanne, Ahiagbah, the last guy, and the cases we are talking about here, no hearing dates were given when the applications were filed or the writs were issued. No hearing dates were given. I'm sure the registry of the Supreme Court might have told them that maybe they will have to consult with the CJ. Usually that is a process before a date can be fixed for that case. So once a date cannot be fixed, you can't go to what time, because no date has been fixed. Look, I hope you understand me. So what the Attorney General says he did was to write a letter. That is not an application for abridgment of time. A letter. That is not an application. You understand me? Mm-hmm. So it's a letter he wrote to the CJ that I want this matter to be listed for hearing on the 27th of March. And that is why the course list for the 27th of March was revised, because the original course list, that case was not on it. So it was revised and the case was added to it by the Chief Justice. I want to believe that the AG is being honest when he says that he wrote a letter to the Chief Justice. So what we are saying is that, you see, Doc, when you send a case to a judge, do you know that you as a party, you and your lawyer, you can't go and see the judge alone? The judge will sack you. Ethically, the judge will say, unless I hear you, go and bring the other party. Because the judge doesn't want to have ex-party communication with any client or any party in the case. When the judge will meet you outside of court, the other parties must be present, because justice must not only be done, justice must be seen to have been done. So the court ensures that in dispensing justice, everybody has trust that the process is transparent, fair, impartial, and so on. So we are saying that if Godfrey Dame wanted an abridgment of time, he should have waited for the Supreme Court to give a hearing date. And usually, once the return date was not on the face, was not entered upon the filing of the process, a hearing notice would be sent on all parties. And if the Attorney General thought that that date was too far, he could apply for the time to be abridged on notice to the other parties. If he wanted to also write to the CJ, which is not, abnormal, it's not irregular. You can write, a party can write to the Chief Justice that this, because of A, B, C, D, do this. But the ethical thing for every lawyer to do is to copy. In any case that you are a lawyer in, if you are writing a letter to the CJ or to the judge or to the registrar, master, this one is elementary law. This one is elementary when it comes to ethics. I'm happy that there's another lawyer in the studio. You must copy the lawyer on the other side. So what the AG...
The other lawyer is interested in the extractives.
lithium and the rest.
Don't come and
but this is trite. You can ask anybody. You must copy.
If
you don't copy them, then it means that you have something to hide. If you are writing a letter to the Chief Justice for a case to be late, we don't even know what is in that letter. So if you have nothing to hide, if there is nothing illegal, nothing unconstitutional in that letter, you show your hands. This is standard. So what the Attorney General has done, claims to have done, if it is true, because we don't even know whether in truth he wrote that letter. But if it is true that he wrote that letter, his claim is conduct. And the leader of the bar should not be conducting himself that way. Ask any lawyer whether if you are a lawyer for a party in a matter, you can write a letter to either the Chief Justice or the Registrar of the Court without copying any of the parties. It is not done anywhere. So please understand it. This is not abridgment of time matter.
Sammy is just moralizing and talking plenty because he knows he's off base. Okay. Really. The matter, the letter or the note you read from the AG's spokesperson or assistant is clear. The explanation there is that you write to seek for expedited hearing because a time was not given in the case. And anybody can do that. I don't know if Sammy is talking about a norm or an express rule in the law that when you write such a letter, you copy the other party. If it's just a norm for good measure, that it is us lawyers, so you write and you give me. But I mean, please, it's not. If it's a norm, then it is not required.
Who told you?
No. Norms are not burdens. They are things for good measure that you will do, please. So if it's not done, somebody cannot come here and argue that as a matter of law he has to. It's not the case. Okay? You see, Sammy, this whole...
Let me read this to you on the basis of this. So there are a lot of... So this as Nana Megache, Justice of the Supreme Court.
Wow.
Atugu, no, not he sending it.
Okay, it's a case.
Okay. So Atuguba and Associates versus Scipion Capital UK Limited. Okay. So this is Nana Megache JSC sitting as a Supreme Court judge in the matter. I says, quote, the instruction from the respondent to the appellant is to request the appellant to engage in an ex parte communication with the judge. We find this request unfortunate, especially coming from a firm of solicitors in the United Kingdom. We condemn the directive in no uncertain terms and reiterate that Ghana is not one of the countries where ex parte communication with judges is permitted. The rules of judicial conduct in Ghana prohibit judges from engaging in ex parte communications. Lawyers are also prohibited by the rules of legal ethics from communicating with a judge in the absence of the opposing counsel.
That's what I've told you.
Ex parte communication is an attempt to overreach the opposing party and influence the judge to decide in favor of the party making the contact. An ex parte communication undermines the fairness of the justice delivery system and an ongoing judicial proceeding and creates a dent in public trust in the legal and court system. We wish to state that the justice delivery system is the last hope of the citizenry in a democracy. When everything else fails them, the justice delivery system should not fail them. It is therefore important that rules put in place for the justice system to thrive and serve the citizenry without fear or favor are respected by all, Ghanaians and foreigners alike. End of quote.
So,
are you going to debate?
Well, please, Sammy, just relax, okay? What he said is not what is happening.
Why?
That what you just read.
Why?
Communication with the Chief Justice in respect of seeking a case to be heard.
Yes.
Okay?
Yes.
It's not a conversation seeking to advantage one over another. It is. Wait, please.
All is
in this matter, he's saying that the content, content of the conversation.
It says lawyers are also prohibited by the rules of legal ethics from communicating with a judge in the absence of the opposing counsel.
That's it.
Ex parte communication, which means that the communication without
the notice, the other party. I hear that.
It's an attempt to overreach the opposing party and influence the judge to decide in favor of the party making the contact.
Okay, so in light of what you just read, I tell you that it's not applicable to an acceptable rule of one writing to seek for a case to be heard expressly.
Is that
I'm saying, wait, I'm saying,
How?
is it the case? Is it the case that a lawyer can write, or party in a case can write for a case to be heard earlier because of some reasons?
But not
that
expertise.
No, I'm saying that. I mean,
By a mandated DSC.
yes, but I'm saying that facility, is it available? Is that facility available?
Yes, but not expertise.
No, I'm just saying.
Yes.
He didn't say on that matter, on this matter specifically, that what is allowable in law, that yes, in a case where a time has not been determined, and then you, a party in the case, seeing that the case is urgent, in this case, there is no way you can tell me that holding the president's nominees in abeyance.
No, that's not the point.
But I'm saying
the issue is that
I agree.
Why would the other parties in the matter?
Yeah, but you see,
Not be made aware.
If you just hear me out, hear me out,
yes.
the evolution of the rules and ethics are based on sound logical reasoning. Is that not the case? So that there's opportunity for you, because in a case that a time has not expressly been given, but you know the matter carries weight and has implication, okay, on the state's business, so that you, Attorney General, writes. It could be my brother Roxon, who is writing to say that we want this matter to be heard today or tomorrow.
Be at the blind side?
But what is the blind side? There is no blind side in this matter. The question is, the question is that, the opportunity to write for early hearing of the case was available to both of them, right? And the Attorney General, seeing the value of the implication of that injunction, writes for that case to be heard. He is not saying that hear it in my favor. He said that we want to hear the case early. And then please hold on. No. But that's what the rule was saying. Judge, please.
Without
Sammy, be quiet. No, be quiet. What what you read from the Nyamagachi said is quite different from what case is this that Attorney General write for a hearing, because there is no time given expressly for the case, and you, the Attorney General, finds that is affecting government. That's not the same thing he's talking about. He's talking about ex-party communication that will tilt. Okay, that will have a conversation in the benefit. If you read what you just read, it says that in the benefit,
lawyers are also prohibited by the rules of legal ethics from communicating with a judge in the absence of the opposing counsel.
Yes. Now, what is the impact of that? Saying that so that the case will be, influenced by that communication.
So that you don't overreach.
No.
Yeah,
exactly. That's what he's saying.
But I'm just saying that have cause to suspect the judge of bias.
Sammy just
that is the reason for that.
And then you are just indicating that to support. But the point I'm making is that the availability to write a letter to say that I want the hearing be done sooner because a time was not given in that case was available to all lawyers. And that, when you write the letter to the Chief Justice or the court seeking that time to be brought forward or a time to be set and set sooner, the court then writes to the person to come to court. So that is not an exclusionary process. It's a process to say that, Syria, I want us to start the program early. And you, who is our host,
are you doubting that I can get a common sense bit you're dealing with?
Yes, that's all there is.
No, please. Are you doubting that per the rules of court, per the ethics of the legal profession, ex parte communication is unethical? Are you saying that it is not the case?
I'm not saying that.
So what are you saying?
What I'm saying to you is that in this case, the application or the letter he's writing has basis in practice.
Which practice?
The practice to say that you can write to seek for a time in a case, okay, that is before the court, that the time has not been given. I'm just saying,
the ethics say that although you can do that, it must not be ex parte.
So what is compromising? Well, of course, what is compromising about let's hear the case early, and it's the written letter. Upon receipt of that letter, you, the plaintiff in the case, will be notified that the date for this matter has been set, and which service was given, and you said you shouldn't accept it. So the point we are making is that we are trying to make the minor the major,
just last,
and the major the minor, and that for me is very worrying.
It came out in the Kennedy Japan versus Anash case that indeed the the Honorable Kennedy Japan had written to the judge, to the Chief Justice, asking for a change of the judge. And this was done without recourse
to the other parties.
And indeed, the Chief Justice went ahead and acceded to this request without recourse to the other party. They only found that out when they got to court and realized that the judge in the matter had been changed. And that the judge in the matter had been changed upon a request by a party
to the Chief Justice,
to the Chief Justice without recourse to the other parties.
No, please, just hold on, let me finish. You see, Syria, we are not discussing a case with Honorable Kennedy Japan. We are discussing a specific case.
I am not.
Right. I'm going to make a point. Yes, I'm just making.
It's not the Honorable Kennedy Japan.
Yes, I'm making that point.
A practice by a Chief Justice.
Which Chief Justice?
I'm saying that it's something that was done. This same issue.
Was it with this Chief Justice?
No. I'm saying that it doesn't matter.
No, I'm just asking.
Yeah,
to be clear. Okay.
Then Megachi, I believe, has even left the Supreme Court, right?
Yeah.
Yes.
He's retired. Yes, so. But I mean,
Richard,
that's not fair. I'm just saying that.
No, please.
I'm just saying that if they say that the ethics prohibits ex parte communication, it prohibits it.
Yeah. So
whether it is in Ahiagbah versus the state or Abe versus the state, it doesn't matter.
But of course, listen, the communication you read from the Attorney General's aide or spokesperson is clear that facility that they leveraged to inform the office of the registrar to say that we need a time, because a time was not set on the matter, cannot by any means, any stretch of the imagination, be a compromising communication such that you want the other party to know, or you are seeking the Supreme Court to tilt a case in your balance, which is what the evidence that you read from the Magache stated. That's not it.
All right.
So all there is that when the case was filed, a date for its hearing was not stated. And so therefore, as an Attorney General who knows the magnitude of that delay, a possible delay in that case on government business, has written to the Supreme Court, the Supreme Court or the court, to give a date which is sooner. And I don't think that contradicts anything.
Unfortunately,
PENDREAM TV now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.